The new Texas Indemnity Bill. This is a presentation that was given at the Tales of Risk Management seminar by Adams Insurance and Memco. I'm Andy Adams. Before we look at the new legislation, let's take a look at where we've come from. What's the current state of the law for Texas Indemnity? Basically, anything goes, as long as it meets the express negligence tests and conspicuousness tests under Texas law. There have basically been three classes of indemnity over the last several years. The broad form, or more commonly known as the sole negligence indemnity, is an indemnity form that requires the indemnity, who's the person giving the indemnity promise. Usually this is the subcontractor or the specialty contractor in the relationship. Requires the indemnitor to indemnify, hold harmless, and defend the indemnity, even where the indemnity is solely negligent. This is the type of indemnity that really irks some specialty contractors because it is perceived as unfair, and that they are required to indemnify someone for something that they had no involvement in and was entirely the negligence of the other person. The third form, skipping over intermediate for the time being, is a limited form indemnity. This is the kind of indemnity where you are only required to indemnify the other party for your own negligence. So this would be kind of on the opposite end of the indemnity spectrum from the broad form. In between, and it can be any place in between, is what's known as intermediate form indemnity. This is sometimes known as a concurrent indemnity. Now this can be anything that required you to indemnify if you were even 1% negligent and the general contractor or the owner was 99% negligent. As long as you have at least 1% negligence, you're still required to indemnify in full. That's commonly known as the intermediate form. So up until the new legislation, this was the state of Texas law regarding indemnity. So what is the new indemnity statute? Well, the statute is identified as House Bill 2093. And very basically, it only allows the limited form of indemnity. It applies to construction contracts entered into after January 1st, 2012. Here's the text of the law. Section 151.102, a provision in a construction contract is void and unenforceable as against public policy to the extent, and that's important language there as we'll come back to in a minute, that it requires an indemnitor to indemnify, hold harmless, or defend a party, including the third party, against a claim caused by the negligence, and then skip over that next language, of the indemnity. Okay, that's the essence of the statute. And again, it limits indemnities to just the limited form. You will no longer be allowed to sign an indemnity or enforce an indemnity that requires the indemnitor to indemnify the indemnity for the indemnity's own negligence, whether it's a sole negligence indemnity or even an intermediate form indemnity. Now, of course, there are exceptions to every rule, and this statute is no different. One of the big exceptions is the exception for employee claims. This basically exempts from the new indemnity rule any claims for the bodily injury or death of an employee of the indemnitor. These are the subcontractor employee claims, commonly referred to as a third-party oversuit, where a subcontractor employee is injured on the job. He cannot sue his own employer because he's barred by workers' comp statute. So they routinely sue the general involved in the project, perhaps the owner, or even other specialty contractors. There will be an exception in the new law for these types of claims. So you can still enforce an indemnity, even a sole negligence indemnity, when there is an employee claim at issue. It's a pretty big exception. Here's some more exceptions. What's interesting in how this law was passed the exception for employee claim was in the law as it was originally written. But just before it passed, two more exclusions found their way into the law. The first one you see there, 10A, a single family house, townhouse, duplex, or land development directly related thereto. So basically, any home builder and the projects that it conducts for individual homes will be exempt from all of the requirements of the law. B, a public works project of a municipality. There's some question about what this is actually referring to or describing. At a minimum, it would seem to indicate that any public works type project for a city in the state of Texas would also be excluded from the scope of the statute. So, bottom line, a sole negligence indemnity will still be enforceable for construction projects related to single-family residences and then also public works projects for municipalities. That's basically the law. What does it all mean? Let's take a look at the big picture of what this new statute will mean going forward. First, I want to note that the statute also applies to additional insured endorsements on general liability policies. These will not be a workaround available to general contractors or owners to add themselves an additional insured even in cases of their own sole negligence. The statute will prohibit those as well as against public policy. Statute will not apply to contracts signed prior to January 1st, 2012. Those will continue under the old law. In addition, when you combine this with the fact that there's a 10-year statute of repose in Texas, it's pretty clear to see that we'll be dealing with sole negligence indemnities for some time to come, even outside of the subcontractor employee claim. Don't be fooled into thinking you don't need your contractual liability coverage in your general liability policy. We suspect that in the future, going forward, some carriers will argue, hey, you don't need coverage for contractual liability for sole negligence because that is void against public policy in Texas. Well, as an initial matter, you will need it for the exception claims based on subcontractor employees, but also you have a whole host of indemnity agreements that you've signed over the last several years that this new law will not apply to. You still need that contractual liability coverage. The exception for subcontractor employees is a pretty big exception, but does it swallow the rule? Is there any point to the statute when you consider all the exceptions that are there? I think the answer to that question still is yes. While the subcontractor employee exception is a big exception, there is no exception for construction defect claims. And frankly, over the last several years, those seem to have eclipsed subcontractor employee claims as the predominant indemnity claim we see filed against specialty contractors. So the indemnity rules will apply to those defect claims, and we think that will be very significant. Does it require redrafting the indemnity contracts? The shorter answer to this is yes. There is language in the statute that says to the extent that it violates public policy, it's void. That's code language for it's reformable. It's possible that a judge could look at a old style indemnity, let's say a broad form indemnity that now is in violation of law, and reform it according to the new law and say, I'm not going to enforce the sections that are contrary to the new law, but I will enforce the sections that aren't contrary to the new law. You want to take that decision out of the judge's hands. And the only way to do that is to have your indemnity agreement redrafted. So I think it's definitely a good idea to have it redrafted. That's something that your attorney is going to like to hear. Will it result in increased litigation expenses and insurance costs? And this is anybody's guess, but our speculation is that it will result in increased litigation expenses and insurance costs. Why is that? Well, as it exists today, when you have a broad form indemnity, as unfair as it is, you still have a commonality of interest between the contractors in that vertical tier of contract with the indemnity. It's that tier and it's that group of contractors against the plaintiff. The indemnity agreements between them create a commonality of interest. And so really the only argument is between that group of contractors and the plaintiff over what are the damages and whether there is any negligence or common law defenses available. Well, with the new indemnity law, you will no longer be able to have a broad form indemnity or any kind of indemnity for someone else's negligence. Now what's going to be key is what is the negligence of the individual contractor. That's going to lead to whether or not his indemnity obligation is enforced. And this will destroy that commonality of interest and basically result in finger pointing among the contractors. Whereas before they all were kind of lined up and their interests were aligned, now they're going to be concerned about who is really at fault and proving that. I think the end game of that is increased litigation expenses and more work for attorneys, which will result in increased insurance costs. What about customer relationships? That's another thing that loss of the commonality of interest could put a strain on. We routinely hear from our customers how it's very important that the insurance carrier respond in a timely fashion because their retainage or their working relationship with the general contractor, the owner at issue, is being strained because of the lawsuit. Well, how much more is it now going to be strained now that the insurance carrier will be concerned about making sure they are actually negligent under the new law? That could put a strain on customer relationships. What about the increased use of controlled insurance programs? We've heard that quite a bit, that this is going to increase the use of controlled insurance programs. And if the other things are true, that this will result in increased litigation and insurance costs, it may very well increase the use of controlled insurance programs. But this is going to depend on the perception of owners and their willingness to pay for those controlled insurance programs. I think at this point it's too early to say whether that will actually result in an increased use of SIVs. But in the long term, it very well might. This concludes this presentation.